Okay, so we're going to look at free and appropriate public education as the next principle. And so, again, each of these principles in their present state have evolved in relation to the history, have evolved from the history, I should say. And so, essentially, the 14th Amendment really is one of our first um, documents, writings, language that addresses FAPE in that we cannot deny any person's equal protection of the laws. And these provisions of FAPE are universal to all persons, regardless of race, nationality, and everyone has or should have equal protection of law. So how does the law define FAPE? It's defined as special education and related services that have been approved and that they meet the standards of the state educational agency, and they're appropriate at the preschool, elementary, secondary levels, and that they are also based on individualization. So the appropriate has to meet the individualization for the child. So IDEA mandates provide students with disabilities, FAPE, and we know that special education is defined as specially designed instruction that's individualized with the necessary related services. However, the law really doesn't give us more than that. It doesn't give us substantive standards for what is appropriate and adequate. We do have a number of court cases that help us to define appropriate, but we do know that the IEP is a legal document. There has to be specially designed instruction on the IEP, and but that a caution from the courts tells us that we can't impose on the school districts methodology. So in other words, the experts in the schools are the ones that really are responsible for the curriculum and methodology. So one of the first cases that involved free and appropriate public education come from a case of a little girl named Amy Rowley. And at the time, which was 1982, when this decision was rendered by the courts, it dealt with a child who was deaf and could have perhaps benefited more with having a sign language interpreter throughout her school day. And what this decision rendered really was that specifically appropriate consists of a program that provides a student with a reasonable, and that's an important term, a reasonable accommodation or opportunity to benefit. So it doesn't really even give us, a definition of what reasonable is or what benefit means, but there has to be a reasonable benefit. So in this particular decision, many people think it was unfortunate. The court decided that Amy was making progress, and so she was not entitled to the best. She was entitled to services that gave her reasonable opportunity to benefit. So appropriate is defined resulting from an appropriate non-discriminatory evaluation, an appropriate IEP, and an appropriate environment or placement, an appropriate opportunity for parents to have meaningful participation, and due process procedures that are not violating rights in any way. So in terms of appropriate, again, we get more, I'd say, more information, more definition from the No Child Left Behind Act, as well as we know IDEA really parallels No Child Left Behind, and so we're looking for appropriateness in that the public education is of the highest quality and it's designed to meet standards. So the FAPE requirements in Section 300.300 of the federal law, the Individuals with Disabilities Education Improvement Act, have been amended to make clear that services provided to an eligible child must address all of the child's needs. So we can't just focus on, say, one area of need. It has to focus on all of the child's needs and be based on the identified needs of the child, not necessarily their categorical label, their disability categorical label. In Pennsylvania, where I'm residing, the law, the regulations are Chapter 14, and essentially what also is addressed in terms of FAPE is that the special education plan from the state into the local education agencies ensures access to a full continuum of placements as required on the student's IEP. And that will conclude FAPE.